Hey everyone, Judicial Watch President Tom Fitton here with our weekly update on social media. So much happening. I don't know if we'll be able to track it all this week, but we've got two new election integrity victories, a big lawsuit over Trump's assassination, a lawsuit over lawfare, plus updates for you on the impeachment issue related to judges, the lawfare against President Trump, and a wave of violent terrorism targeting conservatives, namely Elon Musk, and just generally Americans that we've never really seen before in recent American history. So very troubling developments in that regard. First up, though, is the big debate about the role of the judiciary in the fights about what President Trump is able to do or should be able to do under his constitutional authority. And what the left has done is they've gone to court after court in well over 150 cases, seeking almost emergency-style relief to stop Trump from engaging in government reform, firing people, protecting the military from transgender extremism, engaging in analysis of data for evidence of waste, fraud, and abuse, protecting the sovereignty and national security of the United States by expelling aliens who are here in violation of law, all of which has been challenged successfully to a large extent by the radical left, which is fine. You know, the left is going to go to court and they're going to do what they can. That's an opportunity or an option that they have. The question is, should the courts buy into it? And too many courts have bought into this unprecedented relief that they've been seeking that has effectively turned the judges into co-presidents of the United States, something that's contrary, in my view, to the rule of law and to the U.S. Constitution as delineated related to the separation of powers. The judicial branch is supposed to be judicial, and they're not supposed to be exercising legislative or executive powers. And so we've had a case in Maryland where a judge effectively took over the Social Security Administration. I think I had a tweet about it. Let's go to that tweet. Obama judge effectively, again, takes over Social Security Administration at the behest of Democratic donor unions, and that's what these public employee unions typically are. She rules that President Trump's administration's his employees at the administration, go back to the tweet because I want to get the language right, can't access data to try to uncover waste, fraud, and abuse. So the acting head of the Social Security Administration looked at this over-the-top ruling and concluded that the ruling is written so broadly that the Social Security Administration may have to be shut down completely. And because when you tell a president and people that she terms to be Doge that they can't access information necessary to do their jobs, and you define it in such a way that everyone in the Social Security Administration is covered, then that's a problem. Another problem is you had Judge Anna Reyes, who is a new Biden appointee, relatively, I guess she's been on the bench 2 years now, here in Washington, D.C., who essentially outlawed President Trump's efforts to restrict the service of certain transgendered individuals in the United States military. Essentially, he is re-implementing a rule he had successfully implemented from his first term. And Judge Reyes' decision effectively makes her commander-in-chief on this matter and tells the president he can't exercise the judgment, really, that he alone has as commander-in-chief as to who's suitable for military service. And when you look at her opinion, and maybe we can find it and post it, it's full of unhinged political rhetoric. You know, some of these opinions are pretty awful, and some of them are more straightforward, where they at least try to be sane, however insane the result is. In this case, the decision is just full of political anti-Trump rhetoric using talking points from the transgender extremist movement, just echoed straight by a federal judge. Really inappropriate. And then, of course, you had another Maryland judge, I think it was a Maryland judge, who ruled, and there are a few judges who kind of ruled this way, that President Trump essentially had to rehire tens of thousands of probationary employees that he let go. Again, an extraordinary intervention in the president's right to hire and fire government employees. There's nothing in terms of an emergency basis that justified this court ruling. And in my view, you know whose fault it is? It's Chief Justice Roberts, and to a certain extent, Amy Coney Barrett. It's all Chief Justice Roberts' fault. And because he had an opportunity a few weeks ago to rein in a particular court ruling that required the president to broadly spend $2 billion within minutes, effectively speaking, as a result of a court saying, well, you can't control the money here, you have to spend it, you can't even hold it for more than a few days before you have to spend it, because it's disputed whether you're obligated to spend it, so we're just going to cut to the chase and make you spend it on foreign nationals in support of the UN and Lord knows what else. And Chief Justice Roberts could have just said, that's an abuse of power. We've got to stop that from happening, and it would have sent a signal to the other judges. But instead, he and Justice Coney Barrett voted with the three liberals on the Supreme Court over the objections of their four colleagues, more conservative colleagues, at least in this issue. And now it's Katie bar the door from our judiciary. And the biggest issue in terms of public controversy has been rulings, or the court case before Chief Judge Boasberg, who is the chief judge here in the District of Columbia at the district court level. And what happened was that President Trump, about a week ago, issued a proclamation under the Alien Enemies Act. And what is the Alien Enemies Act? It's a powerful tool given to the President of the United States to protect America from invasion. And it essentially says that aliens can be designated, if they're so designated, if the proclamation so designates them, they can be removed immediately by the president. There's no question about it. And here's the specific language from the Alien Enemies Act, which was passed in July of 1798, and it looks like it was signed into law by the President of the United States at that time, John Adams, and it's been used rarely since, usually only in times of declared war. But as you'll see, there's good reason to use it now in light of Joe Biden's invasion. Section 1. Be it enacted by the Senate and House of Representatives of the United States of America in Congress assembled, and they were assembling up in Philadelphia. You know, we didn't even have the Capitol yet. That whenever there shall be a declared war between the United States and any foreign nation or government, or any invasion or predatory incursion shall be perpetrated, attempted or threatened against the territory of the United States by any foreign nation or government, and the President of the United States shall make public proclamation of the event, all natives, citizens, denizens, or subjects to the hostile nation or government, being males of the age of 14 years and upwards, who shall be within the United States and not actually naturalized, so not citizens, shall be liable to be apprehended, restrained, and secured and removed as alien enemies. So look at that second part again. Let's bring that up again. I want to read that second part. But obviously, we don't have a foreign war, right? We don't have a war with any declared nation. The president's proclamation relates to the second part, any invasion or predatory incursion. And he alleges, and so states in an official proclamation under this law that's 200 plus years old, that Venezuela's government has engaged in such behavior as it relates to these gang members here in the United States. And so what happened is the ACLU immediately rushed the court. Come back here, I've got that done. As immediately rushed the court was before the chief judge, Judge Boasberg, and alleged that 5 of their clients, they had 5 clients, were Venezuelan nationals, but they really weren't part of this gang and shouldn't be deported. And Judge Boasberg allegedly issued a court order orally saying, bring them back if the plane's left, or they shouldn't be removed, or whatever the vague language was, and then issued a written order. And what the Trump people did was, there were 2 planes in the air. They didn't think they should have to be returned, not under the terms of either the oral order or arguably the written order. And the 5 who were at issue, they actually removed from one of the planes, and they were kept aside pursuant to the judge's order. Now, Judge Boasberg is angry because he thinks his order was thwarted in some way. Trump and many Americans are angry because they think Judge Boasberg was intervening in a way that was improper under the Constitution of the United States, Supreme Court precedent, etc. You saw the power, the awful power the president has under this law, and he made the proclamation. Now, Boasberg is yelling at the Justice Department about whether his order was flouted. And it doesn't look like it was. Was it followed closely and not in a way that gave it an overbroad nature? No. But this is an issue that's a legal fight back and forth, and how it turns out to me is not nearly as important as the underlying authority that Judge Boasberg seemingly is asserting, which I don't think has any constitutional basis. So the danger isn't, the fight over Trump versus the judge over following the order. The danger is the judge asserting unconstitutional authorities in a way that constrains the president, because he issued almost immediately a broad order, a class action ruling, essentially saying every person who was covered by this proclamation can't be removed. That's not what the law allows. The Trump administration tried to get the appellate court to move quickly on it. As far as I'm concerned, the court has been kind of stalling. And they go through in the brief this appellate ruling, or excuse me, this appellate brief, describing the proclamation. And they don't want to tell you, the big media doesn't, because they want to pretend that Trump is acting lawlessly. That his proclamation meets to the letter and spirit the requirements of the Alien Enemies Act that authorizes him to remove these alien threats from our nation. The president made findings that members of the transnational criminal organization, TDA, I don't know how is the name pronounced? Aragua? I've read it, but I've never heard it pronounced, believe it or not. In conjunction with a narco-terrorism enterprise backed by the illegitimate regime of Nicolas Maduro, the crazed dictator of Venezuela, are conducting irregular warfare and undertaking hostile actions against the United States. And that's in the preamble to the proclamation. TDA, the transnational gang connected to the government President Trump finds, has also engaged in and continues to engage in mass illegal migration to the United States for several purposes, including to inflict harm on U.S. citizens and support Maduro's regime in undermining democracy. Further, the gang is closely aligned with and has infiltrated Maduro's regime, growing under the governance of the leadership down there, who's al-Assassination is his name, the gang leader. And he's a fugitive as well. So these cartels, these gangsters that are being run by the Venezuelans, and I say that reminded me of the Cuban boat lift where they specifically moved into the United States. Do you remember that? They emptied out their prisons and moved into the United States countless numbers of refugees and criminals in order to destabilize America. So the question is, did the president have the right to make the proclamation, and that should it be honored, and can it be second-guessed by the judiciary? And the answer is no, it can't be second-guessed by the judiciary. It really can't. The Supreme Court found the following. It's a famous decision, but back, I think it's I have it in my head, it was in the 40s, late 40s, early 50s. It was right after World War II. The courts have recognized, and this is from the brief, the legitimacy of the Alien Enemies Act as an exercise of war power reserved to Congress and the executive. The Supreme Court has observed that the Alien Enemies Act is, quote, as unlimited, unquote, a grant of power as the legislature could make it. The most expansive power granted to a president that was possible under Congress's purview. That's what the Supreme Court has found. And we have a district court judge here in Washington, D.C., second-guessed the President of the United States, thinking that he had some right to order planes to turn around. Thinking that he could tell the president all over the nation no alien could be expelled under this proclamation issued under a law that's 200 years old, and no one, again, the court has already found, the court whose decision he's obligated to follow, by the way. He may object to the Supreme Court's analysis here, which is fine, but as a district court judge, he's supposed to follow it. The court has further explained that the statute encompasses, quote, matters of political judgment for which judges have neither technical competence nor official responsibility, unquote. No one elected Judge Boasberg, with all due respect, to be president or commander-in-chief or a congressman. I mean, that's the problem with when judges act as politicians in this case, or in these cases. I mean, I know Judge Boasberg. Nice man. Very, very personable. Of course, that's not the issue. His decisions are uniform, at least from my perspective, uniformly horrible on issues that Judicial Watch cares about, and specifically issues that Judicial Watch has been involved in. But he's a liberal jurist. And liberal jurists are tempted, and often do, substitute their political beliefs through their office, through their judicial powers, for the constitutional authorities, or substitute their belief and insert abuse their judicial authority to exercise legislative and executive branch powers reserved to the people we vote for, not to unelected appointed judges. And this court has held, and this is, by this court, I think the brief is referring to the appellate court in the District of Columbia, which the judge is also bound to follow. The statute confers, quote, unreviewable power in the president to restrain and to provide for the removal of alien enemies. The courts have therefore limited their review in prior challenges to very narrow questions. There, the construction and validity of the statute, and whether when relevant, there is a declared war, and whether the person restrained is an enemy alien 14 years of age or older. And obviously, they think the president's proclamation is pretty clear as to meeting the criteria that gives him the power to remove these aliens and designate them as removable under the Alien Enemies Act. And that's what this is all about. Even Trump's worst enemies don't deny he's been following all the court orders, however egregious and outrageous they have been. Does it completely stop his action? No. He pursues action where he can while taking into account court orders. And that's what he did with Judge Boasberg, and then what he's done repeatedly, despite all of the baseless orders, in my view, legally baseless, meritless, whatever the language you want to use. Despite what the leftist tells you, President Trump has been following all of these orders that I think are part judicial coup, part judicial insurrection, part judicial sedition. And some people want to exercise the impeachment prerogative to police this. And I addressed it, or Judicial Watch addressed it in part in an op-ed I talked about last time here in the Washington Examiner, and we had a report bringing everyone up to date as to the debate. Let's play.
Yes, activist judges can be impeached, argues Judicial Watch President Tom Fitton in a recent op-ed he wrote for the Washington Examiner. Fitton writes, the framers of the Constitution address concerns about judges abusing their powers by pointing to the constitutional check on any such abuse. That check, impeachment. In Federalist Paper number 81, Alexander Hamilton explained that while the judiciary may occasionally encroach upon legislative authority, its comparative weakness and total incapacity to support its usurpations by force limits the danger. Hamilton added that this is greatly fortified by the consideration of the important constitutional check, which is the power of instituting impeachments. He further added, impeachment alone is a complete security. The last time Congress used its impeachment powers on judicial activism was in 1804, when Supreme Court Justice Samuel Chase was impeached by the House for, among other alleged misconduct, being an electioneering partisan. Chase was acquitted by the Senate. President Trump and House members have called for the impeachment of federal judges who have made controversial decisions that many argue unconstitutionally hijack the power of the presidency. In response, Chief Justice John Roberts issued an unusual statement. For more than 2 centuries, it has been established that impeachment is not an appropriate response to disagreement concerning a judicial decision. The normal appellate review process exists for that purpose. Judicial Watch President Tom Fitton said in response, to the degree the Chief Justice's statement suggests that the practice at the federal level has been to allow judges and justices to go rogue with no impeachment check, he is correct. To the degree he suggests that this is what the Constitution and the law require, he is wrong. Go to judicialwatch.org to learn more.
So, as we note in that report, President Trump wants to impeach Judge Boasberg. And I think the articles of impeachment may have already been filed in the House. And he had a statement as to the correctness of his cause under the law here on Air Force One the other day.
Criticism that the Alien Enemies Act has only been invoked 3 other times. They were all during times of war. Do you feel that you're using it appropriately right now?
Well, this is a time of war because Biden allowed millions of people, many of them criminals, many of them at the highest level. They emptied jails out. Other nations emptied their jails into the United States. That's an invasion. And these are criminals, many, many criminals, murderers, drug dealers at the highest level, drug lords, people from mental institutions. That's an invasion. They invaded our country. So this isn't, in that sense, this is war.
He's right. He's right. Where's the outrage over Biden allowing this invasion? Isn't it interesting? Few judges made comments in that regard, even though that was the more dire threat to our constitutional republic. When I thought, by the way, what's interesting about that video I noticed is how hardworking Trump is. He came back and was talking to the press corps on Air Force One at 11:39 p.m. I think it was 11:39 p.m. It looked late. And he just never stops. And I think Chief Justice Roberts made a terrible mistake in issuing this statement. I think it was a political statement. It is rightly being seen as a critique of President Trump, a critique of members of Congress. And so I guess the chief has every right to make a statement like this. It's his prerogative. But I tell you, if he's going to engage in politics, there's going to be political pushback on it, right? If judges are going to be engaged in politics, the political branches will respond politically. And a political response under the Constitution, as we've highlighted here, is impeachment. Is Judge Boasberg going to be impeached by the House? I don't know. I don't know. Is one decision or enough to warrant impeachment? I don't know. Impeachment is what the majority of the House, an impeachable offense is what the majority of the House approves. I mean, you may think it's not enough for impeachment. I think when one looks at all of these judges who have issued some of these outrageous rulings, I think you'll see a history and pattern of judicial activism and, in my view, abuse of power under the law, where they substitute their own judgment improperly for elected representatives and other designated authority under the Constitution. And I tell you, in the least, as I note in this tweet, Chief Justice Roberts' political statement, essentially, he comes down on the side of politics here. He says the court is making this stance, at least he is, on this political debate, because it is a political debate whether to impeach a federal judge. And what bothers me about his statement is I think it's designed to suggest that you can't impeach judges. And that it's, quote, as he said, it's inappropriate. Well, it's not been seen as inappropriate. There's been a debate about it. But it's not, quote, inappropriate. Maybe that's his opinion. That's his opinion. That's fine. But a Chief Justice, when he issues a statement like that, it suggests that there's law behind it and that he will impose the law as it relates to it. Not only that, it sends a signal to these lower court judges who are abusing their powers. Don't worry, I'll protect you from impeachment. And if I were in Congress and if I were running the Judiciary committees in the least, Chuck Grassley runs the Senate Judiciary Committee. Our friend Jim Jordan runs the House Judiciary Committee. I think highly of both individuals. Chuck Grassley is one of my favorite senators. They should invite the Chief Justice to testify about impeachment and his views on impeachment. And if I were in the House, this is what I would do. I would initiate hearings about the impeachment power of the House as it relates to federal judges. Go through the issues that I explore in my op-ed, where I go through the framers saw impeachment as a key tool to rein in an out-of-control judiciary. And if the Congress thinks the judiciary is out of control and that the Supreme Court, as evidenced by Chief Justice Roberts' prior decisions and his statement here, is not going to provide sufficient protection for our republic, then impeachment is possible and may be necessary. Now, of course, the challenge is impeachment means that the process of impeachment has two parts. So in the House, a judge becomes impeached upon a majority vote for an article, right? So you're impeached for offense X. It's kind of like an indictment. And then the trial, if there is to be a trial, because I think the Senate doesn't even have to commit to a trial, would occur in the Senate. And in order for someone to be convicted under impeachment, according to the Constitution, I think it's a 67 vote. It has to be 67 votes. I think it's 3/5. So that's going to be a tough haul in a Senate that is so closely divided. 50, what is it, 53-49 or something like that? So does that mean you don't do impeachment because the trial may go one way or is likely to go one way? I don't think that's, that's a practical concern and a political judgment. So if you think the House should engage in the impeachment process against some of these judges, you need to let them know, because in the end, it's all politics, right? There's no law that says House can't impeach a judge for an activist decision. In fact, the Constitution, the framers specifically allowed for it and encouraged it to be used as a check. So call your House members and let them know what you think. Call your senators and let them know what you think. 202-225-3121. That's 202-225-3121. What do I think is going to happen in the end? I think a lot of these cases that restrain Trump are eventually going to fall flat. They're not going to be upheld at the appellate level or be significantly curtailed either by an appellate court or Supreme Court rulings. I think many of some of his biggest moves, like the Alien Enemies Act, I think ultimately he's going to prevail. His efforts to restrain and basically put an end to the constitutional abominations from his point of view of so-called independent agencies created by Congress that he supposedly can't hire and fire to the full extent necessary, and get Humphrey's executor overturned. What is Humphrey's executor? I should have done some more reading on it. But the first question you may have is, what is Humphrey's executor? That's a strange name for a case. I think it was Mr. Humphrey was someone who was fired. I think it was by FDR, and he died, but he had litigation. So his estate continued the litigation, and so the executor for Humphrey continued it. So the case became captioned Humphrey's executor. And the Supreme Court essentially found that these independent agencies that constrained the ability of the president to run them, or by essentially hiring and firing the members of the agencies, was constitutional. And President Trump said that's bunk, they're not constitutional, and there have been decisions since then that have undermined key aspects of Humphrey's executor. And so President Trump is taking action, asserting his constitutional authority. It's being challenged in the court, which is appropriate. And now the Supreme Court eventually is going to have to decide whether that's good law or not under the Constitution. And I think he's going to prevail there. But who knows, given Justice Roberts, Chief Justice Roberts and Amy Coney Barrett's hesitation to uphold presidential power. So my point is, we are in crisis now constitutionally. I'm hoping it settles down. And the danger in the meantime is that the courts will abuse their authority and undermine key government reforms in a way that can't be undone, right? Time's a wasting. This president has just 3 years remaining, 3.5 years remaining, practically speaking, right? So every month, every week, every day that he's constrained from reining in and protecting the republic is a day that can never be gotten back again. And the courts know that, who are doing this. The leftists know that, who are doing this. They're trying to gum up the works. I mean, what else would you expect them to do? So this is time we can't get back for self-government. So I think talking about impeachment is useful because it puts courts on notice that the public is upset about what they're doing, and hopefully they'll follow the law rather than politics. Hey, Yeah, there's a guardrail of the Supreme Court. There's a guardrail of appellate review. There's also a guardrail of the constitutional check of impeachment. Okay? And hopefully the result is the judges will stay more carefully on the straight and narrow. Now I say that because, I don't know, maybe that's the triumph of hope over experience. But we've got the rule of law. We've got to follow it. And don't you believe Chief Justice Roberts that impeaching judges for activist decisions does not comport with the rule of law? He's plain wrong on it. In fact, it may be necessary. And the other concerning thing is that, the left isn't satisfied with pursuing the rule of law. We've seen in the last 2 weeks, we see this with, frankly, the Venezuelan fight here with Judge Boasberg. We see this with the fight over President Trump trying to detain and deport foreign nationals who support Hamas or Hezbollah. So as far as I can tell, there were 3 people who have been detained under this process that have at least been public who have gone to court. One is a Columbia University student, or former Columbia University student. He was promoting Hamas on campus, running protests designed to essentially drive Jews out of Columbia. So a terrorist supporter, foreign national, he should be expelled. Toot sweet. The second is a woman a foreign national who traveled reportedly to Syria to attend the funeral of a Hezbollah leader. Thankfully, they said you can't come back into the country, so that's in dispute. The third is another foreign national whose father-in-law and wife are Hamas operators, based on what's out there in the public domain. So do you think people who are involved with terrorist organizations who are foreign nationals should be here in the United States? I don't think you do. But the courts are intervening to stop the removal of some of these individuals. But at least they're being held. And so what does the left do? They go to court, but they also engage in violence. And here, that you had Islamists and leftists, supporters of terrorism, attack the World Trade Center again. Look at this video.
So here we have leftists and their allied Islamic terrorists attacking the World Trade Center again. And of course, the left media supports it and encourages it.
And of course, incidents like that have been happening all over. The terrorist left, terrorist supporting left, is out there supporting terrorism. Not only that, they're engaging in terrorism directed at a federal official, Elon Musk, through Tesla, attacking not only his companies, his showrooms, Tesla operations, dealers, etc., but American citizens who own Teslas. And what does the left do in response to that? They laugh about it and celebrate it. Look at this video from, I think it's from a Comedy Central show where the audience is live laughing at the reports of terrorism targeting American citizens and companies.
They're taking to the streets or the parking lots.
Tonight, the FBI and ATF now investigating multiple cases of possible arson targeting Teslas and Cybertrucks.
This dramatic video shows multiple cars in flames. Police say the attacker used Molotov cocktails. It's the latest in more than a dozen instances of arson and vandalism targeting Tesla.
The same suspect shot more Teslas with a gun. Tesla Cybertrucks were set on fire in Kansas City, and earlier this month, shots fired at a Tesla dealership in Oregon. Cybertrucks on fire in Seattle.
Wow, you guys like petty acts of domestic terrorism, huh?
Ha ha ha, right? You know, and I feel badly for Elon Musk. He's completely horrified at this. Here's a video of him talking about it.
I mean, it's really come as quite a shock to me that there's this level of really hatred and violence from the left. I always thought the left, or Democrats, were supposed to be the party of empathy, the party of caring, and yet they're burning down cars, they're firebombing dealerships, they're firing bullets into dealerships, they're just smashing up Teslas. Tesla is a peaceful company. We've never done anything harmful. I've never done anything harmful. I've only done productive things. So I think we just have a deranged. There's some kind of mental illness thing going on here, because this doesn't make any sense. And I think there are larger forces at work as well. I mean, I don't know who's funding it and who's coordinating it, because this is crazy. I've never seen anything like this.
Yeah, you can't help but feel for the man. He's completely aghast at what's happening to him, and he doesn't understand why. I understand why. Because these people are communists, and that's what communists do. They use political violence. The left loves political violence. And the Democratic Party has been, in too many ways, embracing this radical element within their midst and promoting it. And he's a federal official, so it's about Tesla, but it's about the government. And you have the former vice presidential nominee, current governor of Minnesota, laughing about the attacks on Tesla. Look at this.
How do you fight it? This
I think I could kick most of their ass. I do think that if they wanted to. I know I can outrun them, but I don't know if we're going to fall into that place where we want to. Okay, we challenge you to a WWE fight here type of thing.
And then he's in front. That was such a ridiculous video. I mean, I do those videos. Sometimes I feel like I want to crush my phone rather than just do the video because it's just so outrageous. But watch this attack on Tesla more directly here. You have the governor of Minnesota talking about fighting his political opponents, kicking their you-know-whats. It's absurd. And then he's targeting Tesla, specifically getting the crowd to target the company further in this video clip.
We took that video down in the debrief.
Oh, we don't have that one up. Well, anyway, you've seen the video of him, celebrating Tesla's stock tanking. So what to do about this? I don't think there's another video I have. I don't think I have another one. What to do about this? This is what I would recommend to President Trump. This is a dangerous movement targeting his government, specifically Elon Musk, targeting our government, the Trump administration, the president Americans elected, duly elected, constitutionally elected, and they are trying to disrupt the government by attacking Tesla and Elon Musk, who is a federal official. The President of the United States should invoke the Insurrection Act, deploy the National Guard to Tesla dealerships and other places the left are attacking. And any and all attacks on Tesla owners should be prosecuted by the federal government in addition to any state charges that the states can bring. Now, do you manufacture charges that wouldn't necessarily be covered by the federal level? No. But to the degree the federal law prohibits this type of terrorism directed either at Tesla or citizens in order to engage in what looks to be sedition and an insurrection against the government, it should be fully prosecuted. So yes, what's happening with Tesla is part of a left-wing insurrection, and it should be dealt with accordingly. Now, President Trump wanted to invoke the Insurrection Act last term in the face of the left's efforts to destroy our cities, burn his White House to the ground. And he didn't do it because he had people who hated him around him who opposed enforcing the rule of law and didn't think these issues were important enough to invoke the Insurrection Act over. Well, I tell you, if American citizens can't be safe in their own homes because the leftists are engaged in this roving violence, that's exactly what the National Guard's there for. Certainly, in the least, they should be protecting dealerships and other places of business related to Tesla, because now that's being targeted as a result of a federal official helping the president in the White House. And it's obviously a direct attack on him and as directly the government of the United States of America. Insurrection 101, this is what President Trump should do. I mean, the left doesn't give up. They like violence, they like terrorism, and they do it whenever they think they can get away with it. Now, Pam Bondi, they've been aggressive in going after some of these Tesla terrorists, as I call them. You know, Trump has encouraged that prosecution as well. I think there needs to be more needs to be done to secure the public safety and our government. Okay. Well, now on to some good news when it comes to the rule of law and election integrity. We had two decisions in recent weeks related to election integrity. The first one, as it relates to Judicial Watch, was over our lawsuit to end the counting of ballots received after Election Day. We had a lawsuit in Illinois. It's on appeal now because the court said a member of Congress who is a candidate doesn't have standing to challenge illegal vote counting, which is crazy. In Illinois, they count ballots that arrive for up to 14 days after Election Day. In Mississippi, they count ballots that arrive for up to 5 days after Election Day. California, 7 days after Election Day. And we just sued in California over that for Darrell Issa. And in our lawsuit, we alleged there were two congressional races whose results were changed and Republicans lost as a result. And those results were changed as a result of ballots that were unlawfully counted because they were counted despite arriving after Election Day. But the good news is that we had an affirmation or reaffirmation in a dramatic way in our Mississippi case. So in February of last year, we've sued. And then in October of last year, essentially the case went up to the Fifth Circuit Court of Appeals. And in that case, we're representing the Libertarian Party. And in Mississippi, the Libertarian Party sued, saying counting ballots that arrive for up to 5 days after Election Day violates the plain federal law that sets Election Day as, quote, a day. And if the ballots aren't there by that day, too late. And the appellate court indeed did rule on October 25th, 2024, that Congress statutorily designated a singular day for the election of members of Congress and the appointment of presidential electors. Text, precedent, and historical practice confirm this day for the election is the day by which ballots must be both cast by voters and received by state officials. because Mississippi statute allows ballot receipt up to 5 days after federal election day, is preempted by federal law. We reverse the district court's contrary judgment and remand for further proceedings. So that was a massive win. It was the first appellate ruling finding the counting of ballots after election day is contrary to federal law. It's unlawful. So there was an appeal. Now, when an appellate court rules against you, a three-judge panel here, I'm not a lawyer, so take this for what it's worth, because I'm sure there's a lawyer out there who's going to think of an exception to what I'm about to say. But generally speaking, you can appeal straight to the Supreme Court, or you can ask the full Fifth Circuit Court of Appeals. So the Court of Appeals has more than just three judges who hear an individual case. There's a whole slew of them. And depending on the appellate court, they have, the numbers change depending on the size of the appellate court and their jurisdiction. California's got an entire Congress worth of judges, it seems to me, at the appellate court level. But you can appeal to the full court. You can say to the appellate court, take a look at this panel decision, and the full court should consider it. And this is in lieu, at least, or it's one step you can take before appealing it to the Supreme Court if you want. And that's what happened here. They asked the full court to hear it en banc, which is literally what that means, the full court hearing it. And the court rejected the request to rehear it by a vote of, I think it was 5 to 10. So only 5 judges wanted to rehear the case. And the case or the decision is worth reading, because sometimes they just reject it without comment. But here it was a split decision, and the dissent was vociferous, despite the law being clearly on our side. But the Fifth Circuit got it right. Got it right. I think I have the decision here. Did we print out the decision? Yeah, I found it here. It's on this other side here. And I'll read you a part of the decision from the majority, or one of the majority judges. And this is a killer here. According to the dissenting opinion, states should be free to accept ballots for as long as they'd like after Election Day. That is, of course, a question for Congress. But even if it were a question for federal judges, do our dissenting colleagues really think that federal law imposes no time limits at all on ballot acceptance? True, statutory deadlines prescribe dates by which the certification of presidential electors must occur. At best, those provide a last-ditch backstop several weeks after Election Day. At worst, they permit states to engage in gamesmanship, experiment with deadlines, and renew the very ills Congress sought to eliminate: fraud, uncertainty, and delay. And nothing whatsoever prevents the states from innovating with ever later ballot receipt deadlines, 2 months or even 2 years, after Election Day in congressional elections. The dissenting opinion's only response is to say, states are unlikely to do that. But such pragmatic assurance only underscore that the dissenting opinion lacks any legal limit. So, as a result of this decision, that's the law of the land, at least in the Fifth Circuit, is you can't be counting ballots that arrive after Election Day. Louisiana, there are 3 states in the Fifth Circuit. Louisiana doesn't do it. Mississippi did do it 5 days after Election Day, so they have to stop now. At least that's my understanding. Now, they could appeal to the Supreme Court. I don't know what's going to happen next. And in Texas, they count ballots that arrive they let ballots arrive the day after Election Day, and they count them. So Texas is likely going to have to change their law as well. So it's an important decision. It further solidifies our case in California. It solidifies our case in Illinois. And hopefully it sends a signal to the other Mississippi's one state. I think there are at least 18 other states. 19, I think, if you include D.C. They count ballots that arrive after Election Day. It's not like it happens all over the country. It's less than 20 states. And it needs to stop. Either you have an Election Day or you don't. And as the dissent notes, if you don't, all bets are off. So a great decision. Kudos to our lawyers in our election division here at Judicial Watch. We've got former DOJ attorneys. Russ Nobile was on this case. Our election division is run by Robert Popper, former DOJ attorney, civil rights attorney. Just great work by our legal team. This is a momentous, historic set of decisions obtained by your Judicial Watch on a matter of national importance. If we have elections that can be rigged or treated in a way that the American people can't have confidence they're not fraudulent, it's the end of our country. An essential first step to restoring the rule of law on elections. And if you're supporting our work, thank you. We couldn't do it without you. And if you're not, this is a pretty good reason to do so. But before I move along from this, there was a fun part of the decision, because one of the judges wrote a decision attacking big law. And I'm going to read from it because it's not apropos necessarily of the underlying claim, but he really calls out the machinery of the left that comes in and fights Judicial Watch in these types of cases. And it's written by Judge, I think it's James Ho. It's James C. Ho. He's a circuit judge. This is not the first time, and it surely won't be the last, that opposing political interests will cross swords over whether and how election deadlines should be enforced. Our court reached the same outcome that we do today. That is, we set aside a state law because it conflicts with deadlines set by Congress. The Supreme Court unanimously affirmed, so we applied the same principles to the state law challenged here. And he's referencing another case, Foster versus Love, which I'm not sure what that case is. But this is what he goes on to say. My distinguished colleague, I guess one of the judges, nevertheless suggests that this case may be unusual and thus remarkable because, quote, top-flight lawyers unaffiliated with the parties have seen fit to offer their views on this case pro bono. The implication is that the panel decision may be so off the mark that leading members of the profession have felt compelled to speak out. But there's another explanation, Judge Ho writes. The pro bono activity, pro bono is meaning that no one paid them to do it, meaning it's volunteer, in this case may just reflect the institutional bias at many of the nation's largest law firms. Meaning they're all a bunch of libs. That's what Judge Ho's saying. Who are you fooling? Legal scholars have documented how major law firms consistently favor one side in highly charged disputes like this. The evidence has led to the belief that major firms are falling short of the great traditions of the profession. The concern is that they have abandoned neutral principles of representation and instead engage in ideological or political discrimination in the cases they're willing to take on. Moreover, professional traditions may not be the only thing that firms are failing to uphold. 2 years ago, the Justice Department advised our court that much of the institutional bias at major firms may also include workplace policies that discriminate on the basis of race or sex, yet remain fashionable in many legal circles. To be sure, evidence of political and other forms of bias doesn't by itself make a particular legal position right or wrong in any given case, but it does mean we shouldn't be surprised when top-flight firms consistently jump in on only one side of politically charged disputes, including this one, whether the law actually supports their position or not. Nor should the firms be surprised when others take notice that they are no longer abiding by the principles of their profession and react accordingly. And he says that we should treat their work as motivated lawyering designed to reach a predetermined result. And whatever firms may choose to do, our duty as judges remain the same, to apply the law in a consistent and principled manner, regardless of whose ox is gored. That includes resolving conflicts between state law and the Constitution, no matter what some lawyers say about it. Whoa! How do you like that from Judge Ho? Judicial Watch has been operating for 31 years, and I'm not aware of any major law firm ever giving us free pro bono work. All of our work has been done independently or with working with small or medium-sized firms that we pay. I mean, forget about even getting free help from these big firms. I don't think they would even take us on as a client or our clients on as clients. But all of these big firms all jump in to help the left time and time again. And it shows you the importance of Judicial Watch and the fact that we have strong support and are able to hire our own lawyers on staff and hire lawyers from the outside where it's needed. I mean, we're lucky. We're lucky because of your support to be able to do that. Because all the money, the big law, are on the side of the left, as Judge Ho aptly demonstrates in this remarkable few pages. So you can read the full en banc rejection of the request for rehearing below. We'll put a link there below. But great news for the rule of law. And it's just the beginning. We've got 3 cases we're currently pursuing to stop the counting of ballots that arrive after Election Day. The Fifth Circuit action is an historic victory for honest elections. And now federal law sets Election Day, not Election Week. California and 17 other states should take notice, as I noted earlier. Great news. We also have some more great news in the area of election integrity. It was a federal court ruling in Maryland that struck as unlawful and contrary to federal law a rule that essentially criminalized using voter registration lists to investigate voter fraud. Yes, that's what they tried to do in Maryland. Maryland is a state controlled by the left. We've already been fighting in Maryland, or fought in Maryland, on that very issue in some respects, because early on, well, let me get into it. So there's a group of voters who challenged this regulation and took it to federal court because they didn't want to agree to access the voter rolls with this restriction in place. And plus they had liability if a state board of elections bureaucrat decided, oh, they were investigating voter fraud. So they sued in federal court, and the federal court agreed with them. And they agreed with them in large measure thanks to a case that Judicial Watch had previously brought in Maryland on voter access to voter registration lists, and our amicus brief, a friend of court brief that we followed or filed in this case. District Court Judge Matthew J. Maddox of the U.S. District Court for the District of Maryland struck down a Maryland State Board of Elections regulation that restricted and criminalized the use of voter registration lists for voter fraud and other investigations. Citing a separate Judicial Watch court victory in Maryland that opened up voter rolls to public scrutiny under federal law, the court recognized that restricting the use of state voters' rolls presented an obstacle to upholding federal voter roll maintenance as required by the National Voter Registration Act. Now, that's the federal law that requires states to take reasonable steps to clean up the rolls. How is it you can figure out if they're taking reasonable steps to clean up the rolls if you can't look at the rolls? That's why there's a portion of the law that guarantees access to the rolls. And they're trying to restrict access in a way that makes it impossible to use them effectively. and would stop Judicial Watch from doing it if it was implemented not only in Maryland but in other states. So it's an important court ruling. Had some material I wanted to read from it. Let's see if I can get to it. In Judicial Watch's National Voter Registration Act request, the statewide voter registration list is almost always the first record required, with fields including the voter's name, address, date of birth, voter status, and the last 5 years of voting history. Judicial Watch uses the records obtained through the public inspection provision of the National Voter Registration Act, along with data from the Election Assistance Commission, which is a federal agency, and the U.S. Census Bureau, to determine whether state governmental officials are in compliance with the law. This is information critical to our pre-suit evaluation of whether a jurisdiction is potentially violating the law requiring list maintenance and whether there is a meritorious claim. And this was the big case that we filed as it related to this issue in Maryland, where they had these restrictions. I think they prevented non-Maryland citizens from looking at the list. At least that was the rule that we were challenging. And the federal court ruled, organizations such as Judicial Watch have the resources and expertise that few individuals can marshal. By excluding these organizations from access to the voter registration list, the state law undermines Section 8I's efficacy. And Section 8I is the section of the law that requires access to information, including voter roll information, about how states are maintaining the rolls. And by the way, it's a rule and a law that you can invoke when you ask your county or state officials for records as to whether they're keeping up with list maintenance as law requires. The law does not require perfect voting lists. It does require the states to take reasonable steps to make sure they're accurate. And the basic reasonable steps upheld by the Supreme Court include, if you don't show up to vote, let's say you don't vote in a federal election, they're supposed to send you a card. Simple postcard. Hey, you didn't vote. Are you still there? Let us know. If you don't respond to the card, or you don't vote in the next 2 federal elections, so that's 4 years in total, I mean, we're talking potentially 5 years in total, they must remove your name from the rolls. But the rolls show other potential issues related to elections. And the left knows that. That's why they don't like people looking at them. Now, there's a lot of information in there, right? The home addresses and things like that. Judicial Watch gets this data. We don't start posting people's home addresses. There's no need to do that. We're not insane. And of course, if we started doing that and harassing voters, there'd be laws we'd be violating. We were just trying to make sure the lists are accurate. And we know what we're doing. Heck, I almost broke my cup. Our litigation, our investigations of voter rolls have led to the removal of well over 4 million names from the voting list. Dirty names from the voting list in just the last 2.5 years or so. And we've got ongoing litigation to clean up millions more. This is what the judge found. And by the way, I want to commend the voter group and individuals who fought this. I spoke to a group of Republicans this week, and David Marshberger was one of the plaintiffs, and I met the other plaintiff. I think I met her, Catherine Sullivan. And they stood up against this lawlessness. They wanted the voter list, and they told David he had to sign off on this restriction. And what David did was he crossed it out and said, I'm signing it, but I'm crossing out this restriction. I'm not agreeing to it. And it ended up in federal court. That's what I like to see. Citizens standing up for their rights under law. It's great. And he won. He took on City Hall and won, or in this case, the state government and won. And to the degree we contributed, we're so excited. We're so excited for these citizen activists. And it shows you don't need to be Judicial Watch to get things done, dear citizens. You can do it on your own, and I encourage you to do that with your own sets of activists in the various states. And there was another ruling in Maine, similar, where Maine was restricting access to voter rolls. And I believe Judicial Watch filed an amicus there, our friends at the Public Interest Legal Foundation. Again, got a court to open up the voter rolls. The use restriction presents a clear and substantial risk of chilling and deterring individuals from seeking to access information subject to disclosure under the National Voter Registration Act. When the individual expects to identify past infractions as part of a broader effort to identify error and fraud in the preparation and maintenance of voter rolls. What legitimate interest the state of Maryland has in the use restriction, i.e. preventing voter harassment, may be satisfied by state laws against harassment and trespass. So they found that the use restriction essentially, as Judicial Watch recommended they do, prevents an unlawful impediment to the National Voter Registration Act, the federal law. State law loses against, or in this case the regulation loses against the federal law. It's preempted by it. It's great stuff. Great victory. In Illinois, we had sued. Illinois, you technically could access the rolls, but you had to drive down to Springfield. So the capital of Illinois is south of Chicago. It's about I think it's a 2-hour drive. And you could look at the list of voters one at a time on a computer terminal. I mean, that's ridiculous. So we sued and successfully opened up the Illinois voter rolls there. That's what I love about these cases. I'm reminded of all the good work that we're doing. Sometimes I forget how much work we do in a particular area. It's just great work. So nice victory for Marylanders. And frankly, it sends a national message. Stop messing with voters who want to secure their elections. And in Maryland, they took the January 6th method, right? Which is to criminalize people who dare to question elections. They don't want you to do it. And in Maryland, they followed the left-wing way of trying to put you in jail if you wanted to raise questions about elections and use government data to raise questions about election. Integrity. And as I talked about last week in Utah, they've got restrictions on voter list use, and it's a Republican-controlled state. And we sent a letter, you better open this material up, otherwise we may sue. So it's Democrats, Republicans that sometimes restrict access to information that voters should have access to. I mean, it's not, we talk about our election integrity work, our election law work, our election for clean, the clean and honest elections, you name it. Maybe it's voters first work, right? Voters first. Voters have a right to expect fair and clean elections and processes that guard that. And when you constrain them from asking questions about it, something's up. So President Trump was nearly murdered last year twice. And he by millimeters, escaped with his life in Butler, Pennsylvania. Here's the video of that terrible day.
Take a look at what happened.
Yeah, I hadn't seen that video in a while, and I was watching it with my colleagues before we came on air here, and I was horrified all over again. I just could not believe that happened. I can't believe it happened, and thank God, truly, that he survived it. And it's not only are we grateful for his life being saved, because I think the country could have been really decimated if he was killed. Of course, the poor man was murdered that day and was shot in the attempt to kill Trump. And Judicial Watch has been second to none in investigating the failures of the Biden administration to protect President Trump. Despite increased threats, in this case, it was a level of incompetence that was inexcusable that led to his near killing, not only once, but then twice, when he was nearly shot by someone who was at his golf course with a gun focused right in on him. So only, again, by the grace of God, did someone figure out there was someone about to shoot President Trump again. And Judicial Watch has been second to none in trying to get information about this assassination attempt or attempts. And we've done litigation on our behalf and others, and investigations up in Pennsylvania. We uncovered material that had not been disclosed before, some new photos. Let's run those. There's this one particular photo. Can we run the photos? There's a picture of the shooter. They're close enough there to run that picture. There's another picture of him. There it is. He's looking at his phone. So you had authorities close enough to see his phone. And literally, there's the communication of the law enforcement showing who he is. What's he doing there? Crazy looking kid with skinny arms there on his phone, walking around with what obviously was suspicious material with him. You got the picture of him being killed, or his body. Now, what's really outrageous about this shooting death is the subsequent investigation we don't know anything about. We have no FBI records about the assassination attempt. We have no Secret Service records under FOIA released. As best I can tell, there's been not one record under FOIA released to Judicial Watch or anyone else about the assassination attempt on President Trump. Now, is there someone else they're looking at? What's the reason for not doing that? It's because it's a cover-up. Now, the shooting in Florida, in theory, there's an ongoing investigation there. But there was other support for President Trump's security that day. It was Homeland Security investigations. They had Homeland Security officials there, or staff, providing extra security. I think they were probably, doing perimeter and, bag checks and things like that at Butler. But I don't know for sure because we don't have the information yet. And that's why we just sued the Homeland Security Department for records on Trump's assassination attempt, or the assassination attempt of Trump in Butler. The lawsuit was filed after the agency failed to comply with a July 2024 FOIA request for all records, including emails, email chains, email attachments, text messages, video, audio recordings, photographs, Outlook, calendars, meeting minutes, correspondence, statement, letters, memoranda, reports, briefings, presentations, notes, summaries, requests for assistance, agreements, travel records, receipts, or other form of record regarding providing support or manpower to President Donald Trump's presidential campaign rally that was held in Butler, Pennsylvania on July 13, 2024. The request specifically sought records from the agency's Homeland Security investigations, which is believed to have helped provide security at the Butler event. And I was reminded, I posted a video, or reposted a video. I don't think we talked about it before the show, so we don't have it. And it's like we're supposed to move on from this, right? Oh, that assassination was last year. Who cares? It's the Washington way. It's not the Judicial Watch way. We're not going to move on from this assassination attempt. The Secret Service continues to be a mess, in my estimation. President Trump should still be very worried about his Secret Service protection. It was terribly politicized by the Biden administration. It's the agency, from our experience and expertise, we've got much litigation against the Secret Service, is terribly dysfunctional. The proof is in the pudding of Trump being nearly killed twice. I mean, as I watched that video, I don't know about you, those agents tried to protect him. They had agents that shouldn't have been there trying to protect him, meaning they were too short and unable to provide the necessary support. Particularly the female agents, to be blunt. But even that aside, I don't think we played that part of the video, but it was like slow motion getting him out. There still hasn't been sufficient accountability for what went on that day. And we aim to do what we can through our FOIA lawsuit here. Federal agencies need to come clean on the events that led up to the assassination attempts on President Trump. It is now 8 months since the first attempt, and the American people have yet to receive any answers under FOIA on the failures of the Biden administration to protect him. In August of 2024, Judicial Watch received Secret Service records that showed the Secret Service had made it a top priority that diversity and inclusion is not just talked about, but demonstrated by all employees through every action every day. That's what the Secret Service had been focused on. Then we uncovered records from the District Attorney's Office in Butler detailing the extensive preparation of local police for the rally, including sniper teams, counter-assault teams, and a quick response force. I'm glad they were there to help. Then we got body cam footage and photos you saw from the assassination attempt from the local police in Butler. And we haven't gotten any records from the FBI and Secret Service. We may sue further on them. So if I were Kristi Noem, if I were the head of the Secret Service, if I were the head of the FBI, if I were the head of the Justice Department, or if I were President Trump, I'd say let it all out. I mean, you don't give away, security secrets in a way that would place people at harm. But they know what we want, right? And make it available. We shouldn't have to sue. We really shouldn't. But even under an administration that has an interest in more transparency on issues like this, you still have to sue. Because the federal government, in the end, is still the federal government. And pray for President Trump's safety and the safety of everyone else protected by the Secret Service, or in this case, Homeland Security, because the record isn't very good, and I'm not trustworthy that the competency issue and the agency is going to be protected even under the new leadership. That's for sure. So Judicial Watch has been second to none in exposing the lawfare against President Trump over the years. And I mean going back 10 years at this point. Almost 10 years, yeah. It's almost 10 years. And one of the folks who has been at President Trump's side through many of those years, and most recently, specifically, is Christina Bobb, who is a former lawyer for President Trump's operations. And Christina now is working with Judicial Watch. She's a member of our legal team. So I'm very excited to announce that Christina Bobb, the former Trump lawyer, who's done so much work for Trump on especially election issues, is now part of the Judicial Watch team. We just hired her. But not only that, we just filed for her 2 new lawsuits over the lawfare targeting her specifically. We sued the FBI after they failed to respond to a FOIA request about her. There's a nice picture of Christina. The lawsuit seeks all related investigative reports, intelligence products, or similar products records, as well as all records of communications between any official or employee of the FBI and any official employee or representative of any other branch or department or agency or office of the federal government mentioning or referring to Bob. How many records could there possibly be? What's the holdup? Cash, call your office. We also sued Homeland Security after Transportation Safety Administration responded to a request for all records regarding Bob's enrollment at the TSA PreCheck program and any cancellation or suspension of that enrollment. So you can imagine what happened to Christina as a result of her being brought into the various lawfare being waged by the Biden gang against Trump. She's worried she was leaked and targeted with abuse and retaliation at the TSA. Christina was an attorney for President Trump from 2022 to 2024 before joining the RNC, the Republican National Committee, to assist election integrity efforts for the 2024 elections. She was also part of Trump's legal team during the Biden Justice Department's pursuit of the classified documents case. And she had to run over, as I recall, to Mar-a-Lago when the FBI, the Biden FBI, rampaged through Trump's home in Mar-a-Lago. She used to work for One America News. She wrote a good book, Stealing Your Vote, The Inside Story of the 2020 Election and What It Means for 2024. And she's been a friend of Judicial Watch for years. And she used to be she used to work at the Department of Homeland Security. And she's a former Marine. So she's a great woman. We are pleased to have her helping Judicial Watch's legal team. And not only that, we're also pleased to be helping her try to get some information on the lawfare targeting her. Remember, President Trump was obviously the #1 target, but they wanted to make life painful for everyone around him, including Christina Bobb, our new Judicial Watch employee, and these new lawsuits are designed to get out the truth for them. So welcome aboard, Christina. We just have to keep on keeping on, right? And in order to be successful, we got to bring on staff now and again, and Christina is an excellent addition to our already high quality and nationally recognized superstar legal team for you, the American people. So with that, I wish you the best. A lot going on, a lot more to come, and this is why I hope to see you again next time on the Judicial Watch Weekly Update. Thanks for watching. Don't forget to hit that subscribe button and like our video down below.